putting it all together, creating a hiring and screening program. My name's Laura, and I'm in compliance at Backtrack. We're pleased to have John Hyman back with us today presenting the webinar. A couple of housekeeping things before we get started. The live webinar is eligible for 1 general recertification credit through the HR Certification Institute. Be sure you complete the survey at the end of the webinar, and we'll email the certificate to you later this week. The webinar is being recorded and will be sent to all who have registered for it. It'll also be available on our Backtrack website. And if you have any questions during the webinar, please feel free to type them into the control panel, and they'll be answered at the end of the webinar. So now I'll turn this over to John to get started. Thanks, John.
Thanks. Good afternoon, everybody. It's good to be back with everybody for the 4th in our series on, and I think in this series, creating kind of a compliant hiring program. Hiring is one of the most important issues to a business, getting the right people in the door and filling positions with the right people. But it's also one of the most difficult because it is an absolute roll of the dice. You really have no idea when you hire somebody whether or not they are, whether they're who they say they are, whether their credentials match, whether they're really qualified to do the job, whether they're going to be a hard worker, or whether they're going to be the employee that they think you're going to be when you hire. For those that were with us for the first in this series of webinars, you may recall I told the story about my grandfather who liked to finish liked to kind of start the end of his day with a cocktail or two, a little happy hour before dinner every night. And he was, we would go down to Florida to visit, and I'd watch him every night pour these drinks for himself, or sometimes he'd have friends come over. And one night he was getting ready for one of his friends to come over for this little happy hour in their sunroom, and he noticed that his bottle of Absolute that he kept in the little bar was empty, and so he went into his closet to fetch what I thought was going to be another bottle of Absolute, and what he actually brought out was a bottle of kind of the cheap drugstore plastic gin vodka that he opened up and then filled up the bottle of Absolute with, put the bottle of the plastic jug back in the closet, what was now a bottle of Absolute filled with this clear clear liquid, back on the bar, and his friends came over. He made the cocktails, and nobody was any the wiser that their cocktail for the night, which they thought was Absolute because it came in an Absolute bottle, was actually pick your brand of cheap plastic jug dime store vodka. And I mean, hiring is no different. Employees from the outside all look the same. They all present well on paper. More often than not, they're going to interview well, and you really don't know what you have sometimes until it's too late. Sometimes until you take that first sip and you think, this doesn't taste quite right, and then it's not until you wake up with the awful hangover the next morning that you realize maybe that wasn't Absolute, I was drinking after all. And it's really no different with hiring. And so what we're going to talk about today is kind of how we put it all together, what kind of tools are available to us as employers that enable us to start vetting the backgrounds of employees, so we can have some level of confidence that the people are who we think they are. And look, I mean, if this was a perfect world, it would be as simple as picking up the telephone. So-and-so works for ABC Company. You pick up the telephone, you call the HR manager, CFO, whomever of the company, and say, this is XYZ Company. We see that so-and-so, John Doe, job applicant, worked for you 6 months ago. Can you tell us what we're getting here? We all know as well as I do that that is a kind of candid discussion unless there is, some kind of close pre-existing relationship where you can have a more candid off-the-cuff discussion, off-the-record discussion. Those types of candid conversations just don't take place. If you call a company for a reference, what you get most often than not, almost always, is name, rank, and serial number. Yes, I can confirm that John Doe worked here from this date to this date in this position, period. Maybe you get a confirmation of salary. A lot of companies won't even go that far. And it's not that there's anything legally wrong with providing truthful information in a job reference, as long as the information is truthful. There's nothing illegal about giving the information, but there's just this unwritten rule that companies won't do it. Maybe it's a misperceived idea that they could be, that there's something illegal about giving a bad job reference. There's not. Maybe it's this belief that even marginal employees, maybe employees who weren't the best performers, deserve another chance somewhere else, that every company is not the best fit for each employee, and maybe someone who's a marginal performer at one company will be a superstar somewhere else in a different environment, doing something different, working for different people. Whatever the reason, companies just don't give out this information. So it's left to us as employers to look elsewhere to figure out what it is we're getting when we hire someone. That we are getting the absolute that we think we're hiring, and not the and not the pop-offs. And so we're going to talk for the rest of the next 45 to 55 minutes about all these various tools that we have in our arsenal that enable us to hopefully figure out what it is, or maybe more accurately, figure out whom it is that we're hiring before we actually get that employee in the door. And the first of these rules that I want to talk about is the Fair Credit Reporting Act. Fair Credit Reporting Act is the kind of nuts and bolts statute. I like to call it the flaming hoop of background checks, because it is a whole bunch of hoops, a whole series of hoops that an employer has to jump through before the employer can obtain background information on a job applicant from a third party. And when we talk about, while the statute is called the Fair Credit Reporting Act, to think that it applies just to credit information, your FICO credit score or what have you, and therefore doesn't apply to the criminal background check that you're getting on a job applicant, would be to read the statute way too narrowly and to really expose yourself to tremendous problems down the road. Because while the statute speaks of Fair Credit Reporting Act, actually it applies to any information that you obtain from a third party that is going to bear on someone's character, reputation, trustworthiness. And so it's not just going to be the credit information that we typically think of that we get from TransUnion or Experian or whomever, but it's also going to be criminal background checks, educational reference checks, driving record checks. It may even be, if you hire a private investigator to go out and talk to friends, neighbors, family members, whomever of the applicant, it's going to apply to that as well. And there are so it's really going to cover a wide range of information that you're going to get from a third party about an employee or a job applicant, and it's not overstating to say that there are multiple levels of flaming hoops that companies have to jump through in order to make sure that they're getting this information the right way. Because if you don't get the information the right way, if you don't make it through each hoop unscathed, you open up the potential for tremendous liability in class action lawsuits and what have you from groups of aggrieved job applicants or aggrieved employees who feel that you did not follow this very, very technical statute 100% correctly. So I just want to briefly reintroduce the steps of compliance with a Fair Credit Reporting Act compliant background check. So step one is notice to the employee. It has to be a notice that you are obtaining or seeking to obtain a background check, what's called a consumer report from a consumer reporting agency. It is some kind of background check that gathers this information from a third party. It has to be clear and conspicuous. It has to be written in a way that the employee can understand. It has to be separate from the employment application. I would say 1 out of every 2 employment applications I review for a client has this notice as kind of some kind of boilerplate language right on the employment application. The statute says that's a no-no. It has to be separate from the application in a separate notice form. And if you are looking to obtain not just a consumer report that is a compilation of some some information, but an investigative consumer report that is retaining someone to go out and interview people, you have to let the applicant or employee know that as well, that it's not just enough to say that you are getting a consumer report, but it has to be a more broad, a more broad notice to the employee. Step 2, once you get that notice, you have to then get the employee's, consent. It's their written permission to go ahead and do this background check. It can be partnered with the notice, so where the notice that you give has to be separate and distinct from an employment application or other documents. The consent can just be a signature line on the notice where the employee attests or affirms that they understand that and authorizing you to engage in this background check. Evergreen is okay, which means that an employee can give their consent not just for the hiring process, but throughout their employment, so that every time you want to go conduct one of these, obtain a consumer report on an employee, provided they give you their consent at the outset of the hiring process, and that the consent makes it clear that it lasts for the duration of their employment, it's okay. You're allowed to use an evergreen consent by the employee. And look, I mean, if the employee doesn't want to give their consent, if the employee says, "I don't want you prying into my background," that's great. Thank you. Have a great day. But this isn't the company for you. There's absolutely no requirement that you hire or otherwise consider for employment someone that does not want to give you the required consent to obtain this background check. It is again, this is a technical kind of nuts and bolts statute, the hoops you have to jump through. It doesn't say that you have to consider someone for employment if they won't give you the consent that's required for their to get that information on them. Once you give the notice and get the consent, step 3 is you need to certify to the consumer reporting agency, that's the agency that's compiling and providing the information to you, which is an organization like Backtrack, for example, that you have given the notice to the employee, gotten the employee's consent, that you're going to comply with the Fair Credit Reporting Act, and that the information that they're providing you, you will not misuse or discriminate against the individual with that information. That's step 3, and that's a form that if you're using a reputable and credible consumer reporting agency like Backtrack, again, a form that they should be providing to you. This isn't something that this isn't a wheel that you have to invent, but it is a step that you have to follow in order to ensure that you are complying with the statute. That's what you have to do before you take an adverse action against an individual. That is, before you, in order to get the information, in order to obtain this background information, that's what you have to do. Additional steps that are in place if you want to take action based on what you find in a report. And it's a 2-step process. There's a pre-adverse action disclosure, and there is a post-adverse action disclosure. The pre-adverse action disclosure, so you do the notice, you get the consent, you make the disclosure to the consumer reporting agency, you get back a criminal record that shows that job applicant killed somebody 6 years ago, or the person that you're considering to be your CFO filed bankruptcy 3 years ago. You're not going to hire this person. You can't just not hire them. The statute says you actually have to give them a notice, including a copy of the report upon which you are relying, and you have to give them a copy of a document that's available from the federal government called Summary of Your Rights under the Fair Credit Reporting Act, which is a couple-page document that tells employees, individuals, what their rights are under the law. and you have to give them this information before you technically make up your mind about this individual, but in practice, you're giving it to them before you notify the individual that you've made up your mind. The rationale behind this pre-adverse action, and then step 5, which is the waiting period, is that you have to, at that point, it gives the individual the opportunity to determine, to contest the background check if you have bad information, if you have the wrong person. Look, it happens. When I went to law school, I knew someone who got denied application for the bar exam because the state of North Carolina thought she was a felon. Turned out someone had stolen her identity. It wasn't her, who had gone on a shoplifting spree around various convenience stores in rural North Carolina. And it took her a few months to clear her name to let her sit for the bar exam. It happens that identities are stolen, Social Security numbers get transposed, extra letters get added to names, and things get misreported in background checks. This pre-adverse action notice and the waiting period, which is, in the opinion of the federal government, is at least 5 days, gives the individual the opportunity to contest whether or not the information is correct, so that if it's not correct, they can say, hey, look, that's not me. I wasn't in Hawaii in 1973. I didn't kill anybody. They can then do whatever they feel whatever steps they want to take to try to clear their name and prove to you that it's bad information, it wasn't them. And then once that waiting period lapses, whether the individual responds or not, you're at that point free to take the adverse action to notify the individual that you're not going to hire them for the position, they're not going to get the promotion they applied for, whatever the adverse action is, with another notice form called the actual adverse action notice, which gives information about the consumer reporting agency that provided the background screen, another copy of the individual's rights under the Fair Credit Reporting Act and whatnot. Again, a very, very technical statute. Failure to comply with any one of these steps, there's lawsuits being filed all over the country by plaintiffs' lawyers challenging the mechanics in how employers are obtaining these consumer reports for employment purposes, because employers are, stepping on, touching the rim of one of these flaming hoops as they're trying to jump through them, or not seeing the hoops at all and just running right through them. And believe me when I tell you that employers are very, very much getting burned in the process. That's the nuts and bolts of how you obtain a consumer report. What about the information that you get? Are there any limits in place based on the information you get? Let's say, for example, in the example of a criminal record, you go to hire, you're running a nursery school, and you run a criminal background check. You follow all the steps that the Fair Credit Reporting Act says you have to follow, and you run a background check on an individual, and the background check comes back that the individual is a convicted drug offender or a convicted sex offender. What do you do with that information? Do you have to consider the individual for employment? When can you refuse employment to an individual based on information that comes back in a criminal background check? The law says, right? We get wrapped up in the law. The law says, look, there's nothing wrong with using criminal background information and making hiring decisions, as long as you do it the right way. And the law, specifically the Equal Employment Opportunity Commission, the federal agency that enforces our workplace discrimination laws, is concerned about the use of criminal background checks because of something called disparate impact. This means that you are potentially discriminating against a protected class, not intentionally. You're not saying we're not going to hire any African Americans. What the law is saying is you're taking a facially neutral policy that applies equally across the board to everybody, no matter race, sex, creed, national origin, religion, what have you, but that nevertheless, even though it is facially neutral and on its face not discriminatory, nevertheless tends to discriminate against a group over another just by the very application of the policy. Well, what does this mean? At least in the example of criminal background checks, we know statistically that African Americans and Hispanics are incarcerated at a significantly is an understatement, higher rate than Caucasians. I think it's 7-to-1 African Americans as compared to Caucasians, and 3-to-1 Hispanics compared to Caucasians. The rate of incarceration in this country, which means that if you have a policy that on its face disqualifies from employment individuals with criminal records, it means that that policy will necessarily impact certain protected classes, African Americans and Hispanics, greater than it will impact Caucasians. And so we know on its face that the challenged employment action, the use of a criminal background, use of a criminal history to disqualify an applicant from employment, will have an adverse impact on the protected group via whatever statistical analysis you're looking at, whether it's 7-to-1, 3-to-1, what have you. These minorities are going to be screened out at a much higher rate than Caucasians if you use criminal background checks as a qualifying factor for employment. But that doesn't mean the use of criminal background checks is illegal. It just means there's extra steps we have to take to verify or validate their use as a qualification tool for employment. Right? We're not talking about intentional discrimination here. We're talking about unintentional discrimination, the application of a neutral policy that just impacts one group more than another. And so Title VII says that even if a policy has a disparate impact, impacts one protected group at a rate higher than another, it's still going to be okay under the law so long as it's job-related and consistent with business necessity. Well, what does that mean? Well, the EEOC says we want the test to be validated and we want there to be a targeted screen. What the EEOC is trying to do is get away from across-the-board blanket exclusions and build some individuality, some individualized determinations into this process. The EEOC wants to get away from the we will not hire a convicted felon for a job, period, or we will not hire somebody who's been convicted of this class of felonies for this job, period, to we want to look at kind of what the job looks like, what the nature of the offense is, and figure out if there's a nexus between the criminal offense and the job in question so that we can then have more of a comfort level with this idea of job relatedness and business necessity. And so on a first pass, the EEOC wants employers to apply the following three factors to figure out whether or not the felony even matches up with the job in question. So you're going to look at the nature and gravity of the offense or conduct committed, how long it's been since the offense conduct took place or the sentence ended, and the nature of the job held or sought. And really, I mean, as a best practice, you would build some kind of offense table to say the following offenses of this duration match up with this job, and these will disqualify and these won't, or these will pass through and these will give more consideration to. So you're going to have kind of build this screen that will catch certain offenses with certain jobs as a potential match for a potential disqualification. And that's not enough, because then what the EEOC wants you to do is engage in a applicant by applicant, kind of felony by felony or crime by crime, record by record, job by job, individualized assessment to say, is this individual, despite the fact that they committed this felony or have this criminal record, are they nevertheless employable? And they say they want this to be an individual by an individual determination. It's supposed to sit down with the individual and talk to the individual about, the facts and circumstances of the offense, and how many offenses they've been convicted of, and how long ago they were, and have they been clean since they were convicted, and what is their work history, before and after prison, and what are their rehabilitation efforts, and what do their references look like, and have they been bonded by an appropriate agency either before or after prison, and kind of put all those factors into the tumbler, and maybe the individual can convince you that even though they committed this felony a number of years ago, they are nevertheless employable for the job for which they applied. Depending on the job, I will tell you there's some jobs. Look, if I'm running a business with kids, for example, it's going to take an awful lot for somebody with a violent crime to convince me, and there might not be anything they can say that would convince me that they're hireable. But nevertheless, the EEOC takes the position that it is, per se illegal to have these across-the-board or automatic disqualification policies, that for each job, each applicant, you need to engage in this individualized assessment to say, yes, this person is hireable, or no, they're not, based on this, based on this criminal record. Okay. Why don't we just, as a matter of rule, just ask people on the job application, say, look, have you ever been convicted of a felony? And if you check yes, we're just not going to consider you for employment, and we don't have to worry about these Fair Credit Reporting Act hoops by getting criminal background records, or these individualized assessments, figuring out who did what, when, to whom, and why. We'll just put the check mark on the application. If they check it off, thank you very much. Thanks for playing. Go apply somewhere else. We just don't hire people here that have done these things. And as you can imagine, the EEOC also takes the opinion that these questions on job applications, because without engaging in any individualized assessment at all, are being used to screen out groups of criminals, also violates Title VII by having a disparate impact. And this actually has a little bit more teeth behind it, because there are what are called ban-the-box laws. That's laws that make it illegal to put that checkbox on a job application, are popping up all over the country. We don't have it yet in Ohio, where I'm sitting right now. It's currently pending in the Ohio legislature, but has not become the law in Ohio yet. It has become the law in a lot of states. Minnesota, for example, it is against the law to ask that question on a job application. And you also see a lot of private employers also stepping up to the plate and saying, look, we don't want to deal with this mess of it's legal in this state but not legal in this state. We're just going to, because we have operations across the country and we operate in many states, we're just going to, as a matter of course, as a matter of our own internal policy, just ban the box and say we're not going to ask that question anymore. It's a movement that started a handful of years ago and has actually gained a fair amount of traction. To me personally, I think you can learn a lot from a job applicant on how they answer the question, have you ever been convicted of a felony? And it's not just whether they've actually been convicted of a felony, but how honest of it, how honest is the individual? Have they, are they going to lie to you in order to get their foot in the door for a job? And so, to me, I think there's a lot of value in asking that question, but a lot of legislatures and a lot of policymakers around the country disagree with me, and for that reason, it's just an issue to have on your radar, especially if you operate in states, not Ohio, but states around the country, an issue to have on your radar that there are lots of places where it is just illegal to have on your job application, have you ever been convicted of a felony. So that is kind of how you get information about a job applicant before they come in the door. What do you do now with the job applicant? What do you do with the job applicant now once they're in the door? One issue that has gotten a lot of press and has come up a lot recently is what do you do, for example, with religious employees who may need some kind of accommodation, either asked for or obvious, when they apply for a job. Can you, as a matter of course, deny an accommodation to a job applicant if it's perhaps asked for or perhaps obvious that a job applicant needs the accommodation. This has gotten a lot of press recently because there was a case that went all the way up to the U.S. Supreme Court involving Abercrombie and Fitch, in which a Muslim woman wearing the traditional Muslim garb, the hijab, the headscarf, went into Abercrombie to apply for a job and was denied employment because, according to Abercrombie and Fitch, we have a certain look that we want our employees to have, and the wearing of this hijab, this headscarf, doesn't match the image that we're trying to portray. With our employees. In our store, and at the end of the day, the EEOC sued on behalf of this individual, went all the way up to the U.S. Supreme Court, and ultimately the employee at the U.S. Supreme Court won, or the EEOC won on behalf of the employee, and what the EEOC, or what the Supreme Court rather ultimately said, was that it doesn't matter in this case whether or not the store, Abercrombie, knew this employee needed an accommodation or not, or whether it was denying this employee an accommodation that it knew the employee needed because of her religion. Title VII imposes an obligation on employers to accommodate employees' religions, and the application of this policy screened this employee out. And the company should have made an exception, or should have at least considered an exception for this employee under this policy. And because because Abercrombie did not even consider whether or not an exception could be made, this individual was discriminated against on the basis of her religion. Interesting, I think, from an analytical or from a legal standpoint, because again, these laws, at least in this instance, you are talking about intentional discrimination. You're talking about employees being treated differently because of their religion, and I think what the court did in this case was kind of superimpose this more of an impact type theory, they said, look, we don't care whether you know, we just care whether the policy is going to have this impact, and that in and of itself makes it illegal. And so what it's really going to do, I think, for employers, but what do we do for employees that come in the door? It is really going to, I think, force employers to take a more proactive stance with employees' religions to figure out whether or not there are accommodations that are needed. So what do? I mean, you can't say to someone, I see you're wearing a scarf, do you need an accommodation? But you can say to someone, these are the essential functions of the job, can you do these, or what kind of accommodations might you need, and then engage this employee in a discussion to figure out whether or not there are accommodations that you can make to try to get the employee, to try to accommodate some kind of, religious belief that the employee might have. The same holds true with disability accommodations. The two federal statutes that require employers to make some kind of accommodations for employees are the religious discrimination provision of Title VII and the Americans with Disabilities Act and the ADA, which requires employers not only to accommodate employees but also job applicants, okay? And it requires them to provide accommodations that lets them perform the essential functions of the job if an accommodation is necessary to get the employee to perform, or to enable the employee to perform the essential function of the job. And so, what does this look like when a job applicant comes in? It means that you need to have potentially alternate avenues available for job applicants to get in the door. It means that maybe just having a paper resume isn't enough, or maybe just having a computerized application process isn't enough. Maybe you need to have someone available when necessary who can take an application, for example, from a blind person who might not be able to see on a computer or write with a pen and paper to complete and to file a job application. It might mean that if you have some applicant testing that individuals need to pass, that maybe you make an allowance of extra time to enable somebody with a disability to go ahead and complete that testing. It means, what it basically means, what it boils down to, is number one, you have to be prepared to be flexible with how you handle and address these individuals, and number two, you have to be prepared to understand how to talk about these types of issues, not just with employees, but with job applicants as well. That the people that your people that are doing your hiring for you need to understand the potential issues that arise with when you are hiring or considering someone for employment with a disability. That somebody might need an accommodation in the hiring process, and that you can't, as a matter of course, turn someone away just because it's difficult or just because it might pose some burden on you. That you have to, by law, if an individual asks for an accommodation, engage that employee interactively, talk to the individual to figure out, can we make this accommodation? Is there an accommodation that we can make? No, we can't make the accommodation you want, but consider X, Y, and Z. And how can we get you to become, to successfully complete your application with the company? How can we get you in the door for hiring? How can we, if we hire you, how do you perform? What accommodations might you need to perform the essential functions of your job? It's really a matter of training your people so they know to recognize this issue and not shut the door on somebody with a disability or someone who needs a religious accommodation, but rather view it as an opportunity to open the door a little bit wider to see if this is someone that you can, that you can get in the door, and that you can in fact employ. A couple more issues that come up under the Americans with Disabilities Act. One deals with medical exams and drug testing. Lots of companies send people for medical exams before employment. A lot of these medical exams include drug testing. We need to make sure that we're doing this 100% correctly, because the ADA on medical exams is very specific as to when these exams are permitted and when they're not. The ADA, the Americans with Disabilities Act, really breaks this down into three distinct times in the hiring or employment process: pre-employment, but post-conditional job offer, and then during employment. Pre-employment, that is before someone has been made a conditional job offer or conditional offer of employment. Medical exams are absolutely 100% remote. Can't do them. You will absolutely violate the ADA. No ifs, ands, or buts if you ask an individual that applies for employment with your company, or even as a prerequisite to applying, to complete a medical examination. Can't be done ever, period. Pre-employment but post-conditional job offer, really you're allowed to do whatever you want from a medical testing perspective, as long as you're doing it for all employees in the same job classification across the board. So if you require every employee in your company to successfully take a medical exam as a condition of employment once they've been offered the job, no problem. If you require everyone in the warehouse, no problem. Require all of your office staff, no problem. Ask Susie, who looks like she might have some medical issue, but don't ask anybody else, big problem. The medical exam can be done as long as it is done, again, for all employees across the board in the same job category. Okay, you can have them take whatever medical exam you want them to take. And then during employment, it is a job-related and business necessity standard. So you can only have employees during employment take a medical exam if it is if the exam is job-related or consistent with business necessity. Think maybe, for example, like a post-accident testing, return to work testing after somebody's either on FMLA leave or some kind of medical-related leave, and you want certification from a doctor that they're fit to return to work. Job-related, consistent with business necessity. So pre-employment never, pre-employment but post-offer, yes, as long as it's done consistently across the board, and then during employment, only if job-related and consistent with business necessity. Another screening tool that we're seeing lots of employers use is personality assessments or personality tests. This was, for example, the subject of a front-page article in the Wall Street Journal a couple of months ago, the prevalence of these tests in employment. I remember taking one when I think I was a junior in college, tried to apply for a job at the local movie theater to make some extra cash, and after I turned in my test, I never heard from them, so I assume I failed. But these tests have been around for a long time, and employers appear to be using them more and more to try to kind of streamline the hiring process, get a sense of kind of who it is they're hiring, and whether or not the people they're hiring are going to end up being a good fit for the organization. The problem becomes whether this personality test is truly a personality test or whether it is a designed to elicit mental health information. Because while medical exams are okay pre-employment, post-job offer, if it's a medical exam, mental health exams are off limits across the board regardless. And so if the personality test is designed not to elicit personality traits or patterns of behavior or styles of how you get along with people and what have you, but instead is going to give you results that could tend to elicit information about someone's mental health condition, then it's going to be an illegal exam under an illegal mental health exam under the ADA. And what I would recommend if you are interested in using these kinds of personality, emotional intelligence or personality assessments for your employees, either as a screening tool or maybe as an organizational tool, for your current workforce, have a candid conversation with the company. Ask them, how have they verified their test? Have they, how have they verified the results of their test that is not revealing mental health information? Have a candid conversation with the individual, with the company that is providing this test for you, so that you have a comfort level that what you're getting really is personality information and not protected, illegal to use mental health information. The last screening tool I want to talk about, and then I'll open it up for some questions if people have them, is what I call the Google background check. It's the informal background check. We are considering Jane Doe for employment, and we are going to type her name into the search bar in Google or in the search bar in Facebook or on Twitter, or pick your search bar of choice, and we're going to see what pops up. And we want to see how does Jane communicate online? How does she say inappropriate things? Does she exhibit poor judgment by saying racist or sexist things online? Has she ever trashed an old boss on the internet? Has she ever divulged confidential information of a prior employer or a current employer, online? Does she seem like she'd be a good fit for the culture of the organization? There's a whole bunch of good reasons to search online for information about an individual as part of a background screening process. Whether you want to, see if someone's going to match what you're looking for, or if there's something out there, some dirt out there on somebody that might otherwise disqualify them from employment. Good and bad reason, or good reasons to search for good and bad information on a job applicant. That's great. Let's all jump on, let's all jump on board, and let's all look for this information. What are the risks? The biggest risk is the risk to uncover protected EEO, equal employment opportunity information online. And, well, how could you do that? For example, you're thinking to yourself, maybe. Let me give you an example from my real life, and I apologize in advance if you were on one of our earlier presentations this year, because I think this story I've told before, but it's worth repeating because HR HR folks, hiring folks, people that have responsibility for hiring are more and more every year. The numbers of those individuals, those people that are searching online for information about job applicants, it increases more and more and more every year. And yet a lot of companies don't know the right way to do it. And so if you take nothing else out of this today, let it be the following: this story and why you should not be typing job applicants' names into Google to figure out, without appropriate controls in place, to figure out, whether they have some information that disqualifies them for employment or otherwise qualifies them for employment that's kind of hidden about them online. Okay, so I have a 2-year-old, or I have a 7-year-old son now. When he was 2 years old, he spent 3 weeks at the Cleveland Clinic following an endoscopy that did not go so well for him. He was born with a whole bunch of medical issues. The two that we found out when he was in the hospital was, number one, he has celiac disease, and number two, he has a bleeding disorder that was not diagnosed at the time, which is what created the combination of the two, which is what created the hematoma in his bowel that kept him in the Cleveland Clinic for 3 weeks after this endoscopy procedure. Anyway, it was February of 2011. He was at the Cleveland Clinic, and part of his stay happened to overlap with Valentine's Day, and my wife and I are bouncing back and forth between taking care of our other child, his older sister, and the hospital to stay with him, and we'd alternate days that we were in the hospital. And so I'm sitting in the Cleveland Clinic on February 13th, figuring out what to get my wife for Valentine's Day because, well, we're not big Valentine's Day people. I thought it would be nice at least to, a small token of something to let her know that even though, the situation stinks, hey, look, I'm still thinking about you. Okay, so I'm sitting there in the hospital room thinking what to get for Colleen for Valentine's Day, and I'm thinking, well, okay, she's not going to want the Cleveland Clinic notepad, the Cleveland Clinic clock, the Cleveland Clinic T-shirt to commemorate our fabulous 3-week stay at the residence of the Cleveland Clinic. But at the time, I had been blogging for a bunch of years. I still do, and thought, wouldn't it be nice if my wife, who at the time was a stay-at-home mom, had some kind of outreach to the public to share what's going on with Donovan and our family and his medical issues and what have you. And so I sat on my laptop and set up a blog for her, named it, designed it, coded it, whatever, and that was her Valentine's Day gift. And she, from 2011 until when she went back to work in 2013, she blogged pretty regularly about our family and a lot about Donovan's medical issues and his particular genetic disorder, and reaching out. And she met a lot of people around the country going through a lot of the same issues we were going through. And now it's 2013, and now she goes to go back to work. And if an employer would have typed her name into the Google search bar, they would have found her blog pretty easily, which would have led to that employer getting their hands on information about our family, our family members' protected disability, our family members' protected genetic information. And now if my wife then is not hired for a job. Now all of a sudden it is, is there an inference that this person who is qualified enough to bring in, maybe even interview, but all of a sudden drops off the radar once this protected information comes into the company's possession? How does, have you now created an inference of discrimination where one otherwise needn't exist because maybe someone more qualified just was hired? Okay, so that's what could happen, right? You can find a host of protected information on an individual pretty easily online. Medical information, genetic information, religious information. What church do you belong to? You're on the board of a church. What organizations do you belong to? What charities do you support that may lead to protected information? Are you a 45-year-old woman that supports the Susan G. Komen Foundation? And would that lead an employer to maybe believe that you're a breast cancer survivor and therefore might find another reason not to hire you because they want to hire someone that doesn't have a history of medical issues that might keep them out of work? So how do you create this, how do you create a screening, how do you create a process that enables you to screen for the information you want to get? Inappropriate photographs, good communicator, hasn't trashed an old boss, doesn't steal confidential information. How do you get that information without getting your hands on, your mind around the protected EEO information? And the answer is that you have someone external to the hiring process, probably internal to your company. There's vendors that'll do this for you, but there's no reason why you can't train someone in your organization to do it without paying a vendor to do it for you. But someone nevertheless external to the hiring process who's going to do these searches and then provide to the people internal to the hiring process a screened and vetted reports that screens out all of the protected information that the hiring manager not only doesn't want to know but should never know. But gets in their hands the information that they want to know, right? Pictures, confidential information, trash talking to the old boss, whatever. Okay, so important if you're going to do this information, if you're going to go about doing these searches, and my research reveals that more and more, more companies than not are, that we're doing it the right way, that we are not just willy-nilly typing, we're resisting the urge when someone's going to come into your office in 10 minutes to sit down and, let me dig for 10 minutes to see what I can find, so I can, figure out whether this is someone we're really interested in. Resist that urge and put a process in place, train people to do it, train people to do these searches the right way. So with that, that's the end of my prepared remarks for today's webinar. We have time for questions if there are any. If people have questions, I'm happy to take them in the 5 minutes or so that we have left.
All right. Thanks, John. Just a couple of reminders before we do get to the questions. The live webinar is eligible for 1 general recertification credit through the HR Certification Institute. Make sure you complete the survey at the end of the webinar, and then we'll email the certificate to you later this week. And this webinar has been recorded, and we'll send a copy of it to everybody who has registered for the webinar, and it will also be on our website. So we do have a couple of questions. From one of our clients, we have someone, we give the applicant the application to fill out and the release authorization for the background check at the same time. They are separate forms, but if we give it to them at the same time, does that cause any issues with that, with the disclosure being separate and out there for the applicant to know that a background check is going to be done? Is that still going to follow the rules that we have to follow for background check?
Yeah, it should, as long as it's not, the goal here is for it not to be, for the disclosure and the consent not to be kind of buried in the fine print, that you're not using kind of one consent for everything, right? I agree that I'm an at-will, I understand I'll be an at-will employee, and I give my consent for you to run this background check, right? They don't want you burying the information in the fine print, and so it can be given at the same time as part of, a hiring packet, for example, an application packet, provided that the notice and the disclosure, or the disclosure and the consent rather, are on a, are separately given, even if they're done as part of the same packet, that it's not, buried in the, buried as part of the application itself.
Okay. What are your thoughts on a national ban-the-box law as opposed to the piecemeal state and local ones that we have?
Not a fan. I touched on this, and I didn't dive too deep just because of the time constraints of today's session and how much information there was to get through. But I think there are a lot of valid reasons why employers ask the question other than wanting to screen out felons. There are a number of reasons. One, as I mentioned before, was checking an individual's veracity. Right? You want the employment relationship is above everything else a relationship of trust, and when that trust devolves, the relationship is really I think irreparably broken. And if an individual is going to lie to get their way in the door, that relationship is broken even before the employer knows it, because that trust will never be there. And so, one way to figure that out right off the bat was the answer to a simple question: have you ever been convicted of a felony? And and if yes, explain. By really having a very early on in the in the applicant process this check on veracity. What the ban the box movement wants to do is they want to remove this question because I think it presents a barrier to felons re-entering the workplace. And what they want to do is they don't want to remove criminal histories as a qualifying factor of employment. They just want to force employers to get the information themselves. And so to address the first part, the breaking down barriers, there's other ways to do it, right? You can, instead of putting this mandate on businesses, you can put resources towards vocational rehab in prisons and getting prisoners out of prison with a skill they can use and a certification from the Department of Corrections that says so-and-so completed this program in prison, and we verify that they're qualified to do the following kinds of work. And you couple that with tax credits for the hiring of people, certified offenders with certain skills. You give them, you give companies tax credits to hire those people. That's how you break down those barriers. Separately, I think you are, by this ban the box, you're not going to stop employers from disqualifying individuals with felonies. You're not going to change someone's mind. You're not going to, an employer that's not going to hire a felon isn't going to change that practice just because they don't ask the question on the application. What they're going to do is they're going to run the criminal background check much earlier in the process, which is going to greatly increase, it's going to be great for our sponsor here today, but it would greatly increase the transaction cost for employers in trying to screen felons out of employment, because they're going to have to run a lot more criminal background checks, number one, or it's going to result in individuals that should have never been interviewed, for example, and been made conditional job offers. If you decide to delay the criminal background check until when you run all the rest of your checks, after you make a job offer, but before you bring the person on and onboard them, as part of their conditional offer for employment, you also increase your transaction costs because you're letting people that should never get that far in the hiring process get further than they ever deserve getting. And so then you have to start from scratch all over again if you then disqualify someone that late in the hiring process. So it's lots of really good business reasons as to why I think ban the box, whether it's national, local, business by business, or otherwise, to me, just doesn't make a lot of sense.
Okay. This is actually a follow-up to that. If you're a client, you're in the staffing industry, and you have a client who requests an applicant have no felonies, and the felony, let's say, for example, is for armed robbery, and you're applying for a job as a machine operator, what can a staffing agency do to fill the client's needs but still comply with the EEOC?
The staffing agency is going to have to is going to have to engage in this individualized assessment regardless, and figure out, whether or not they can or can't. I think having a provision in a contract that says no felons in and of itself would violate Title VII. And so I think, I don't think the EEOC is not going to, I think, absolve the staffing agency from responsibility if the staffing agency doesn't place the individual because of a contractual provision that says no felons. I think the staffing agency is going to have to go through this individualized assessment on an employee-by-employee basis, and if they think the individual is really qualified, I think they're going to have to pass them on with the. And look, I mean, this is my lawyer hat that's on right now. Okay, they're going to have to pass them on to the staffing agency or to the employer, to the employing company to say, I know you said no felons, but really this person's really good. We want you to take a look at them. That's my lawyer hat. I understand from a business standpoint, you would probably, as the staffing agency, you would probably lose the customer if you repeatedly give them candidates that they've told you they won't consider. But as a matter of course, I think the no felon policy, the no felon provision in a contract, I think probably in and of itself violates Title VII. I don't know if that answers your question or not, but.
Okay. One final question we have. Is it okay to ask the applicants to fill out the screening forms that has a date of birth, social security numbers, information like that on it prior to an interview, or should we wait and give those forms to fill out after an interview because we are asking for date of birth and things like that?
Well, why are we asking for data? I would never ask for date of birth. Why are we asking? I mean, date of birth.
They are used for criminal checks and things like that. So they are needed for the background check, but they're not needed early on in the hiring process.
Yeah, I would do that completely separately from the hiring process. You want to do that at the latest possible. Ideally, you're making conditional offers of employment, and then you're running the background check, as a matter of course at that point, and then you get that information, date of birth, social security number, what have you, as late in the process as possible.
All right. Well, that's all we have time for today. So thank you to everybody for joining us. We will be having another webinar again in January. Stay tuned for information on that, and we look forward to talking with you again later. Thank you so much. Bye-bye, everyone.